In the wake of that dissent, Chief Justice Benson on the Supreme Court wrote three of the most significant majority opinions in the years following in the struggle for racial equality leading up to Brown. I'm going to tell you about two of them because they deal with education. In McLaurin versus Oklahoma State Regents, the Supreme Court got a little noise out there. Hope there's no fire. In McLaurin versus Oklahoma State Regents, the court considered the case of 6 African-American students who'd been admitted to a formerly all-white institution, school, but forced to sit separately in classrooms, libraries, and cafeterias. Chief Justice Benson wrote that setting African-American students apart handicapped their pursuit of an effective graduate education. He rejected the argument that white students might refuse to associate with black students. To him, there was a constitutional difference between state-enforced and voluntary segregation. The last case I will mention is Sweat versus Painter. In that case, the University of Texas argued that it had offered Herman Sweat, an African-American man, a legal education equal to that it gave white students. The university had created a new law school for Sweat in a Houston basement, and it said it was a counterpart to its all-white law school in Austin, Texas. And Sweat's basement school would have a handful of part-time teachers, but would lack a law library, accreditation, and any kind of a decent reputation. Chief Justice Benson focused on the practical differences between the two schools, finding it difficult to believe that one who had a free choice between these two law schools would consider the question close. To him, Sweat was entitled to the rich traditions and prestige of the Austin campus, not the false equality of a Houston basement. Now, McLaurin and Sweat were decided in 1950, just 2 years after Hunt became the first African-American to study at your law school, and 2 years before I graduated from law school. So it doesn't seem so long ago. Tragically, Mr. Hunt died before he graduated from law school here. But the remainder of the 6 pioneers did graduate from this law school. Literally, at the same time, the Supreme Court was deciding these cases I've told you about. And their famous case, Brown versus Board of Education, which went far to close the legally sanctioned discrimination in education in our country. Now, I've said that I want you to be inspired to take an active role in the cause of fundamental liberties for all Americans. And I'm hoping that this school's remarkable chapter will advance that goal for you. It's a compelling example of the paradoxical characteristics of major social change and progress. We go through things like this. Movements are both a collective enterprise and a collection of individual efforts. And the equal treatment of African-American students at this very university, law school, was a result of decades of struggles by countless leaders across the country. I served for some years on the Supreme Court with one of them, Justice Thurgood Marshall. Now, he led the NAACP's legal campaign to end the segregation of schools that produced McLaurin, Sweat, and Brown. And at the end of his days, before he had stepped down as a justice, he told me that he really thought his life had not succeeded in producing the equality he had hoped to achieve for African Americans. He didn't think he had succeeded. When I look around today, I think he succeeded beyond his best hopes. He really did succeed and produced the change that we see. it took also the wisdom and conviction of Justice Harlan and the steady hand of Chief Justice Vincent to make Brown a reality. And progress often begins with failure. I hope we remember that with the economy today. The legal breakthrough of Brown was heralded in many ways by rejecting Justice Harlan's views in his time. And Mr. Hunt's success was no doubt aided by the pressures brought to bear on the school by Clifford Davis, who couldn't get admission here, despite trying twice in the years before Mr. Hunt was admitted. Mr. Davis attended Howard University in Washington instead. Well, breakthroughs almost always open a new chapter for struggle, even when they close an earlier one. The 6 pioneers here broke down the race barrier, but it was decades before African American students generally were treated equally in our nation's schools. And Brown was a landmark decision, but in many ways it was only the beginning of legal challenges of guaranteeing racial equality under law. Just 5 years ago, the Supreme Court once again took up one of the challenges in a case mentioned by the dean, in a case called Rutter versus Bollinger, which challenged the so-called affirmative action program at University of Michigan's law school. I authored that decision in which the court reaffirmed the importance of diversity in education, and I applaud Dean Nance and this law school for their commitment to that ideal. Is a first in a couple of ways. She's the first woman dean in your university's history. As a legal secretary, if I could type well enough, but I didn't take that job. And I did start practicing in Phoenix, opening a small office with another lawyer in a shopping center in a suburb, and other people in the shopping center repaired television sets, cleaned clothes, or loaned money. It was not a high-rent area. I got walk-in business. People came in to see me about grocery bills they couldn't collect, landlord-tenant problems, and other everyday matters not usually considered by the U.S. Supreme Court. And I've since had the privilege of serving, as you know, as the first woman justice of the Supreme Court. Now, what are you students to make of all this? I suggest to you that you will witness your generation's own movements for social change. Indeed, as the story of your 6 pioneers and its historical context demonstrate, in a sense, these movements don't have a beginning or an end. They're part of our nation's ongoing effort to secure fundamental liberties for our citizens. If you seek them out, you will have opportunities to help in that endeavor, whether as public servants like Justice Marshall and Chief Justice Vincent, or as pioneers living lives of example.